ಇಲ್ಲ ಇಲ್ಲ ನೋಡ್ಬೇಕು. ಬೋರ್ಡ್ ಹಾಕಿಡಿ ಅಂದ್ರೆ
ಸರ್ ಮೆಮೋ ಸರ್ ಮೆಮೋ
ಫೈಲಲ್ಲಿ ಇರುತ್ತೆ. ಇದು ಹೊಸದು ಇದು. ಓಕೆ ಓಕೆ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಬೇ. ಏನಾಯ್ತು ತಗೊಂಡು
ನಾವು ಪಿಟಿಷನ್ ಬ್ಲಾಕ್ ಫೈಲ್ ಕೊಡ್ಬೇಕಲ್ಲ ನಾಳೆ
ಅಕ್ಟೋಬರಲ್ಲಿ ಮಾತ್ರ ಬೇರೆ ದಿವಸ ಸಾರಿ ಅಕ್ಟೋಬರ್ 9 ಮಾತ್ರ ನಾಳೆ ಅಂತ
ಅಕ್ಟೋಬರ್ 9 ಎಲ್ಲಿ ಬರಲಿಲ್ಲ ಸರ್, ಒಂದು ಕೇವ್ ಕೊಟ್ಟಿಲ್ಲ ನೀವು ನನಗೆ ಹೇಳಿದ್ರೆ ಅಕ್ಟೋಬರ್ 9 ಬರಲ್ಲ ಅವರು.
ಅದೇ
ಏನಾಯ್ತು ಸರ್?
ಸರಿ ಓಕೆ ಮಾಡ್ತೀನಿ.
ಫೋಟೋ ಹಿಡ್ಕೊಂಡ್ಲಾ?
ಥ್ಯಾಂಕ್ ಯು.
ನಾಳೆ
ನೋ ಅರ್ಜೆನ್ಸಿ.
ಎರಡೆರಡು ಕಾಪಿ ಸಾಕಲ್ಲ?
ಆರ್ಡ್ರಲ್ಲಿ ಕೋಟ್ ಮಾಡಿರೋ ಆರ್ಡ್ರಲ್ಲಿ ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ
ಅಲ್ಲ ಕರೆಕ್ಟು ಸರ್, ನೀವು ಓದಕ್ಕಲ್ಲ ಸಾಹೇಬ್ರೆ
ಅಲ್ಲ, ಇವನ್ನ ಅಡ್ವರ್ಸ್ ಇರೋದು ಅಂತ
ನನ್ನ ಅಡ್ವರ್ಸ್
ನಿಮ್ಗೆ ಓದಕ್ಕೆ
ಏನಕ್ಕೆ ಅಡ್ಜಮೆಂಟ್
ಅವನಿನ್ನೂ ರಿಕವರ್ ಆಗಿಲ್ಲ. ಅವನ ಕೇಸ್ ಕತೆ ಇದು. WPFC
ಸರ್ ನಾನು ರೆಫರ್ ಮಾಡಿದ್ದು,
ಅದೇ
ರೆಫರೆನ್ಸ್ ನಂದು.
ಹೌದು.
ಕೇಳಕ್ ಪರಿಸ್ಥಿತಿ
ನಾನು ಅಲ್ಲ, ನನಗೆ ಹೇಳೋರೆ ಅಟೆಂಡ್ ಮಾಡಿ ಅಂತ.
ಬೆಳಿಗ್ಗೆ ಬೈದಿದ್ದೀನಿ ಸ್ಕಂದ. 3 ದಿವಸ ನಾನು 1 ದಿವಸ ಡೆಲ್ಲಿಗೆ ಹೋದ್ರೆ ನೀನು 3 ದಿವಸ ಲೀವ್ ಹಾಕಿದ್ರೆ ಹೆಂಗೆ?
ಅವ್ನು ಅದಕ್ಕೆ
ಬ್ರ್ಯಾಟ್ 1 ದಿವಸ
ಇಲ್ಲ ನನ್ನ ಮನೆಗೆ ಅವಾಗ ಫೋನ್
ನೀನು ಹೋಗಿದ್ದು ಬ್ರ್ಯಾಟ್ಗೆ ಒಂದು ಬ್ಯಾಟಲ್ಲಿ ಹೊಡಿತಾವೆ
ಹೋಗಿ ಇಲ್ಲ ಸುಸ್ತಾಗಿದೆ
ಬಿಡಿ ಸರ್, ಪಾಪ ಸುಸ್ತಾಗಿದೆ. ಏನ್ ಮಾಡೋದು, ಹುಷಾರಿಲ್ಲ.
ಏನು ಅರ್ಥ ಆಗಲ್ಲ. ಇಷ್ಟು ಪುಸುಕ್ ಪುಸುಕ್ ಅಂತಿದ್ರು ನಮಗೆ. ನಾವು ಜ್ವರ ಇದ್ರೂ ಬರ್ತಿರ್ಲಿಲ್ಲ.
ಹಣೆ ಬರ.
ಅಷ್ಟೇ.
ಯಾರ್ ಕೇಳ್ತಾರೆ ಇವಾಗ?
ಸರಿಗಿರ್ಲಿಲ್ಲ ಬರ್ತಿದ್ವಿ.
ಮನೆ ಬರ ಸರಿ ಇಲ್ಲ, ಅವಾಗ್ಲೂ ಬರ್ತಿದ್ವಿ.
ಅದು ಮರ್ಸಿ ಪಿಟಿಷನ್ 2:30ಗೆ
ಇಲ್ಲಿದ್ಯಾ?
ಬ್ಯಾಂಕ್
ಎಲ್ಲಿದ್ಯಾ?
ಅವ್ರು ಹೇಳ್ತಾರೆ ಇವರು ಅವನನ್ನ ನೋಡ್ಕೊಳಕ್ ಇಬ್ಬಿಬ್ರು ಇದಾರೆ, ನನಗೆ ಯಾರು ಇಲ್ಲಿ ನೋಡ್ಕೊಳಕ್ಕೆ ಅಂತ.
ಹೌದು. ಇವ್ರು ಒಂದ್ ಕಡೆ ತಾಯಿ ಒಂದ್ ಕಡೆ ಅವ್ರ ಹೆಂಡತಿ ಒಂದ್ ಕಡೆ. ನೋಡಿ ಅದು ಲೆಕ್ಕ ಆಗ್ತಾ ಇದೆ. ನನಗಲ್ಲೋ
ನಿನ್ ಮಗನ್ ನೋಡ್ಕೊಳ್ಳೋಕೆ ತಾಯಿ ಮತ್ತೆ ಹೆಂಡತಿ ಇದೆ.
ನನ್ಗಿಲ್ಲ. ಕೊಡಿಸ್ತೀಯಾ? ಬೇಡಪ್ಪ.
100 ಖರ್ಚಾಗ್ಲಿ.
ಆಗಲ್ಲ.
Lordships, kindly, one matter.
Give the memos, no mentioning.
2:30.
No 2:30 matters.
Because
Yes.
auction is to held to be.
Huh?
Auction under the house property.
What, we can stop it tomorrow also, yes. Yes.
Serial number 8. And for the petitioner, colleague is also not, and this matter was handling this matter. Next week.
Have you informed the other side? At the request of and counsel the petitioner, list this matter on 28th of November. No further adjournments. It is submitted that it is already informed to the counsel by the respondent. Yes.
Page number 4, page 1, serial number 2, page 1, serial number 1.
List 4. What few documents?
For the respondent.
List this matter. Anyway, you are also interested for an adjournment. List this matter in the month of January.
Serial list number.
No, January will take. Yes. List next week. Yes.
List number 1, serial number 26, my lord. Fracture injuries, one serial number 26, my lord. Fracture details are not come in the judgment, my lord. Trial court record is required. 26, my lord.
It's coming up for even notice is not ordered to the respondent.
26 serial list number 1, my lord.
List 26, 1 minute.
Yes, my lord. Trial court records is required, my lord, because no details is in the judgment, my lord. Fracture injuries are not forthcoming in the judgment. Trial court record is required, my lord.
Find out.
But serial number 16, my lord.
Serial number?
16.
When which is?
Next to for list number 1, my lord. And then next week, my lord, some document required, my lord. Some document required, my lord.
We will see if required. Yes. Please don't ask for any adjournments in these final hearing matters. If you ask, I'll post it in the month of April. Anybody? Yes.
List number 1, serial number 1, final hearing. Yes, Raju. For appellant, K.R. Venkatesh.
Yes. Yes, please come to the order, the operative portion. I mean, the table. Table, come to the table.
Table in 26 64,800 future earning.
1 minute. How many are the injuries? Injuries.
Injuries, 3 injuries.
Come to that. Where is it?
Deformity of middle C and
Petitioner sustained femur fracture right side, which is shown as previous in nature in the wound certificate. So only one injury.
according to BW2 30% limb mala.
No. Injury is 1.
3 injuries mala.
Where?
Wound certificate is there.
What is that? No, you read what are the injuries. Grievous injury is 1.
Grievous injuries 2 mala.
What is that?
Bleeding, temporal swelling and deformity of the middle T. Swelling of the right eye T below.
So under the head of pain and suffering, court has rightly granted 50,000. How many days was in hospital?
16 days mala.
Incidental expenses.
16 days inpatient mala. 2017 accident mala.
16,000. Then
Loss of immunity is not awarded mala.
loss of earning during laid up period.
Only 3 months.
When was this accident?
2017, 7/1/2017 mala. Please.
Court had taken
3,000
income. 3,000.
3,000. I have stated in the claim petition 8,000 income because of he's taken the 3,000 mala. I mentioned in the trial court
So we'll
only
take
8,000. 8,000 please.
8,000 into how many? You are in 16 days. 80, 32,000. According to the doctor, medical bills 9,000.
Particular limb 30%. The court has taken 10% of the whole body.
Correct.
10% is correct.
Loss of future income.
8,000 to 12 into 18.
Multiplier is?
18 mala.
It's coming to 1,72,800. Amenities, how much is granted?
Not granted, brother. No, single NP is not. Food and nourishment also no amount has been awarded by the tribunal.
I awarded.
Please.
It comes to 3,09,953 against 1,32,953.
My request, the pain and suffering, some amount has to be announced because income has to be taken on lower side, Mala. 8,000, that's the reason.
Please come. Agreed with the award passed in MBC number 99 of 2017 dated 15 November 2023, whereby the tribunal has granted the dated so and so. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 20. Paragraph 20. The claim petition is filed seeking compensation of an amount of rupees 6 lakhs. It is a case of the claimant that because of the injuries sustained in the accident, he has sustained femur fracture right side. As per the evidence of the doctor, he had sustained 30% disability to the limb, and the court had taken 10% as disability to the whole body. When it comes to the income, the court had taken the income at 3,000. When it is a case of the claimant that is earning 8,000 and granted the compensation. Land counsel appearing to the claimant submits that for the injuries sustained by the claimant under the head of pain and suffering, the amount that is granted by the tribunal is not reasonable. Further, the court ought not to have taken 3,000 as the income. The court had failed to grant any compensation under the head of loss of amenities, incidental expenses, and the amount that is awarded at the head of loss of income during the later period is also not reasonable. Next para. There is no representation on behalf of the respondent. As the matter is listed under the head final hearing, this court is not inclined to. This court is inclined to proceed with the matter. Next, having heard the land counsel, the appellant peruse the entire material on record. Considering the grievous injury and other simple injuries, court had rightly granted the amount at the head of pain and suffering, and this court do not find any reason to interfere. He was in hospital for 16 days under the incidental expenses. This court is granting 16,000. Coming to the loss of earning during the later period, this accident had taken place in the year
2017.
2017. As per the table, the notional income is 11,000. According to the claimant, is earning 8,000. Hence, this court is taking the income at 8,000 into 4, 32,000. Medical bills as it is. Coming to the loss of future income, 8,000 into 12 into 18 into 10 by 100 is 1,72,000. Loss of amenities, this court is granting an amount of rupees 20,000. In the light of the law laid down in Mekala so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,09,953. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 1,32,953 to 3,09,953. The enhanced amount shall carry 6% interest. Any delay in this?
Entire amount may be released.
That will be the, yes.
Cell number 2, Chetan B for appellant, Pradeep B.
For the respondent number 2 to 5, Milad, your lordship permitted the claimant to withdraw the amount, Milad, because of recalling application.
No, I will dispose it off now.
Please, Milad.
Yes.
Kindly attend. Date day after tomorrow, my lord. Monday, my lord.
Why?
Chetan is personal inconvenience.
Kindly see the order sheet. my
Pradeep
lord.
is there, give it.
Kindly.
Already, Lordship has had some time.
Hmm.
The deceased was sitting in a mudguard.
Hmm.
Full bench judgment of the Honorable Apex Court, my lord, and regulation.
Pass
28.
over, pass over.
Fine, please
I
do
will
it.
not adjourn, not even one matter in final hearing. I'm making it very clear. Eight things are not there, still I will read the file and
Their
pass on.
location, they took time for settle the matter.
Please, my lord.
So afternoon, whatever it is. Yes, 3.
Sale number 3.
Lord, I am for appellant. Total 7 appeals. Out of that, 4 is death and 3 is injury. Lord, I prepared a notes and
MEC number and MFA number and amount. Yes, sir. Reference.
Yes.
Lord, in the first page, my lord, I narrated the facts in short, my lord. That the accident between
What ground before this court, Mr.
Enhancement.
Enhancement, two insurance company 50-50 liability, they are satisfied the award. So liability and involvement not in dispute.
Insurer of the Innova car, my lord, and insurer of the lorry.
1 minute, 1 minute. Where did you state the MDC numbers?
I will mention all this synopsis. itself.
My lord, I send a detailed synopsis through my learned friend, whether he given.
He has given.
Yes. In MUC 6/2018, my lord, MFA 474/24. My lord, it requires a remand, my lord, only one case required remand. Because, my lord,
Let's go to that.
Please.
My lord, in synopsis I stated.
Where is the order?
Page number 28, para number 27.
28.
My lord, Master Jen Rayan, aged 12 years, my lord.
1 minute. No, where are the issues dealt with? Page number?
28, para number 27 onwards.
Why it should be remanded?
Why I am insisting
The
for
doctor,
1 minute.
the
Yes.
doctor has been examined and he was stated that at this step we cannot assess the disability. That's what, my lord, they want to examine the doctor.
Where is that?
Please. The doctor evidence, my lord, PW2, my lord. Thirty-four, my lord. Para 30.
Please read.
Please. Future income on account of permanent disability. In order to substantiate the case, the petitioner, he has examined the doctor for assessment of the permanent disability as well as functional disability. The loss of future income computed only the claimant suffers loss of income on the account of the functional disability. If the disability does not affect the earning of the claimant in any manner and does not affect his career in any manner, no amount.
Because doctor is not examined?
Doctor examined, he has not stated about the disability.
No, if you read it, in order to so and so, he has not examined the doctor.
Yes, he examined the doctor.
Examined PW2, madam, para 56.
No, I'm referring to paragraph 34.
That,
says
my
he
lord,
has not
there is no
examined.
discussion that.
And even at the end of the paragraph also, it says the petitioner has not examined the doctor who treated
No,
him.
it's the wrong this one appreciation, my lord, because I have evidence of the doctor. Doctor has
So
appreciated.
on this ground, we will, keeping all contentions open, we will remand the matter.
Yes. That is the only thing.
There is no issue with negligence 50-50, the same negligence aspect, 12-year-old boy.
Yes. Agreed with award passed in MSc number 6 of 2018, dated dated 27 January 2023. Payment is before this court seeking enhancement of the compensation. When it comes to, it is a case of the claimant that on 7/4/2016, at about 10:15 AM, when the petitioner was traveling in the Innova car, the driver of the Tata container lorry had parked on the National Highway Road without any indicator or signal in a negligent manner. The driver of the Innova car hit the lorry and caused the accident. As a result of which, all the inmates of the car sustained grievous injuries on the different parts of their body. The tribunal on the issue of negligence, where is that?
Negligence, my lord. Negligence, there is no dispute.
No, I'll record it.
Please. Para 20, my lordship. The conclusion, my lord.
The court I think here it is not mentioned.
The discussion is 20 minutes. The conclusion is, my lord.
There is no conclusive observations are there.
Hundred and 6 minutes.
Huh?
105 and 106 minutes.
End of it.
End of.
Liability section, they apportioned these, para number 7, page
The
7.
above narration of the charge sheet,
Mm.
106 minutes.
Mm.
The above narration of the charge
Court
sheet
has said
reflects
that.
that the driver of the both the
The drivers of the Innova and the Tata, what is that, Tata?
Innova car and goods vehicle.
And the
Truck.
goods, the
Yeah.
drivers of the drivers of Innova car.
Container.
Tata goods vehicle are responsible for the accident. The insurer of both the vehicles are liable to pay the compensation. Hence, the court has held that. Where is this 50% you get it?
Last.
50%.
Last, in the next para it has discussed. 106. Next, my lord. Both the vehicles are liable to pay compensation, the deceased person, injured persons and inmate of the Innova car. The said passenger, they are entitled
But
for
where is the
compensation.
50% they didn't say?
That's not equally, they are stated equally, 3 and 6. 3 and 6, equally.
As paid with their entitled for compensation, respondents of
My lord.
both insurance companies are equally liable to pay the compensation. When it comes to the compensation, the petitioner had sustained, where do you get that?
27.
The petitioner had sustained, as for the wound certificate, he has sustained, that is exhibit P4, he has sustained as many as 9 injuries. As for the opinion of the doctor, injury number 1 to 5, 8 and 9 are simple in nature. Injury number 7 and 6 are grievous nature. The court, under the head of pain and agony, has granted 60,000 towards medical expenses. 17,57,400 is awarded. Comes to loss of future income. The court has observed that as the doctor was not examined and as there is no evidence to show that the injuries have an impact on his future earning, court has not granted any compensation. Next paragraph. When counsel appearing for the petitioner submits that in fact he has examined the doctor,
SPW3.
doctor, but however the doctor has not.
Doctor, my lord.
Quantified, not quantified the disability.
A doctor has not quantified the disability, but the court has observed that no doctor is examined. It is submitted that as on the date of the accident, he was aged about
12 years.
12 years.
He was aged about 12 years, and the injuries that are sustained will have an impact on his future earning. The court ought to have considered it. It is submitted that if an opportunity is given to the petitioner by remanding the matter, they would be examining the doctor. Then counsel appearing for the respondent insurance company submit that when the petitioner had failed to elicit from the doctor what is the disability, there is no question of the remanding the matter would not serve any purpose. Next part. Having heard the counsels on either side, there is a material on record. This court has observed the finding of the court with regard to the future medical expenses and the disability. According to the petitioner, according to the appellant claimant, doctor was examined, he has not quantified the disability. As per the observation of the court, no doctor is examined. Considering the injuries that are sustained, this court deems it appropriate to set aside the award and remand the matter to the court for fresh consideration. Accordingly, the appeal, the award dated so and so is set aside, and the matter is remanded to the trial court for fresh consideration. Without further notice, remanded to the court only as far as the quantum is concerned.
Assessment of disability.
Assessment of the disability.
Disability and quantum.
So, as far as the quantum is concerned, without further notice, the party shall appear before the court on 1st of December, within 2 months from 1st December, the tribunal shall dispose of the matter.
Let's say in the second matter, my lord, 7, my lord, only the mercy petition. My lord, the case of death, my lord, 36 years, husband and minor son.
1 minute.
Para 36.
Yes, 1 minute. 497 of 2024. Arising out of.
Lord, I given the.
This is actually, but where is this 497? 497.
5.
That is MVC number 10.
10.
One by one, my lord, as if goes.
I am going as per the list.
That may be confusing.
3.1 is 497.
497 minute, serial number 5 minute.
Yes, I've seen it. MVC 10.
It's a case of death.
So before we go into this,
please.
First matter, no delay. In the second matter, this is 3.1. Docket order, IA number 2 of 24 is filed to condone the delay of 272 days in filing. For the reasons stated in the accompanying affidavit, the delay is condoned on the condition that they're not entitled, the claimants are not entitled for interest for the delayed period. Yes. Let's go to the table. At page
69, para 69, internal page 54.
5 lakhs, only 5 lakhs.
6-year-old. 5 lakh as awarded as for the Kishan Gopal's case.
476.
No, 5 lakh.
No, I'm looking at the table at page 54.
Internal page 56.
Internal
Para
page
69. 5 lakhs globally awarded.
Paragraph number 68.
Please, next one.
Yes.
It says
Has been referred Kishan Gopal and all.
No, in total, the petition is entitled for a sum of 4,76,000.
No, thereafter, please. Issue MEC number 10, please. Para 69.
Para 69.
69.
MEC 10 of 18.
Oh, it starts here.
Please.
Where is the table in this?
Next
table,
page.
no table, not 5 lakh.
5 lakhs. So what is that? What is that you want, Mr. Shastri?
My lord, this matter, my lord, it is better to keep in abeyance because, my lord, they are just only I requested Pradeep and I also contacted Supreme Court.
My thinking is the Kishan Gopal case as reported in 2013. At the time, the Apex Court has expressed that the notional income 15,000 as per the chart, my lord, 163A, it has not increased time by time bound. Therefore, 30,000 as considered as notional income. Millership could have the same scenario. Millership could have considered 40,000 per annum. It will come 6 lakhs. That could be awarded.
My submission is, my lord, by relying upon the Kishan Gopal and other Apex Court judgment, this honorable court rendered a judgment. It is known to the court also. My lord, in that judgment, Justice Sanjay Gowda taken in scientifically approach how the money value is.
This matter only will lecture.
My lordship could have decided it now itself. Whatever my learned friend is going to address the argument, my lordship, yeah. I have one more judgment. I only, my lord, extracted that. What would be the compensation 2022 on 18 onwards? Likewise, my lord, I have 3 judgments on that. 2 Apex Court judgment, and this Honorable Court recently has held that why 40,000 per annum has to be considered.
My submission is it is better to kept in abeyance.
He is relying on that judgment of Justice Sanjay Gowda.
Sanjay Gowda, and it is now stayed. Now it is stayed. It is stayed.
Then we are if that is state, whatever is the judgment that is in vogue now, that we will follow.
That's what, I am not saying that it has to be dismissed.
My lord, as far as, my lord, one submission, my lord.
What he
As
wants
I-
is, he will wait
No, well-
till the Supreme Court decides
Yes,
on
yes,
that
yes, yes,
judgment.
I'm ready to wait.
Till then
I'm
it is-
ready to wait.
May I make a humble submission? Act passes also referred to the lordship. No judges are waited for that. And even Mukandeva also, Lord, no, present law, what is that? I will decide it, and so many judges decided in my cases
No, no,
also.
no, it is all.
Why should wait for the till disposal of the judgment, please? When it's going to be disposed, we do not know.
My lord, I will
Aged
check
about
my
60 years.
luck later.
He's aged about 60 years old. He is aged about
6 years.
6-year-old.
Correct.
If 14, 15, we also,
That we were taking
Adolescence
as
and
per the
all, my lord,
notional
yes.
income.
that's what.
My lord,
If an learned friend wants to enlighten my lordship, I don't want.
Anyhow, we'll adjourn this matter. This matter in the month of February.
sorry, sir, extremely sorry, my lord, extremely sorry.
Series of matter, my lord, one matter dispose, one matter not.
It's okay, it doesn't matter.
No.
302, 3.2, MBC, MFA. 502,
502 second.
The
seal number
7 bar
7 of
2018.
2018.
7, my lord.
Hmm.
Para
Well,
13A.
This case also I am indulging, I am praying for the
What is,
sympathy of.
this is, what about this case?
My
No
lord, it's a
interference
death
is required.
case.
As per chart, income, consider escalation,
Nothing,
everything is.
I will not adjourn the matters like this, Mr. Shastri. If you
No,
ask
I am
adjournment,
not, no, I am not seeking for adjournment, my lord. I am seeking the sympathy of the court in this case.
Oh,
Sympathy,
No,
that's
we
it.
will,
That-
we will,
My lord,
we will.
lady,
Where is that?
my lord,
Para-
36.
What we do is, Mr. Shastri, what the page numbers and all, Pradeep is here, he will tell. Any submission I'll ask, then you can make, so it will be easy for the court. Yes, where is it?
Okay, no problem, no problem.
The para 36 onwards, there is a discussion.
Para 36.
36 onwards. The table is, my lord, internal page 38.
Hmm.
The date of acquisition 16, my lord. The MSCT,
Internal page 30.
internal page 38 table.
38 is table.
Table.
Paragraph number?
Para 36 onwards, discussion.
Yes. No, table is where?
Table 38, internal page 38.
Yes. It's a case of death.
Death, my
What
lord.
is the age?
36 years.
36 years.
36
Which year is the accident?
2016.
How much the court?
9,500.
Huh?
9,500.
First
Correctly.
Same has been taken.
40% future prospect.
Everything is
Okay.
okay.
Everything is
Escalation,
How many are the dependents?
Yeah, 2, my lord, 88,000 granted. 2, my lord, 88,000 granted.
Is awarded.
Yes, my lord, 16,500, but that time, my lord, rightly granted 10% is
Correct. I am not disputing. That is why start point, I seek the sympathy of the court because, my lord, a lady aged 36 years working in SBI as an assistant, daily wages. Also, she is a housewife. And also doing designing and painting work in this. So some amount monthly.
There is one judgment with regard to the lady, her contribution to the family. There is a judgment. Where is the give that?
So I am not insisting to
I
take
think
much.
must be aware of it.
But, my lord, there is no any material to show that, my lord. Then, my
No,
lord,
she-
Not about other things. I'm not talking about the other avocation. About her contribution to the
To
family.
the family only. It is, my lord, is only left to the discretion of the court. I am not murmuring anything. Only since a lady 36 years, she is having some job and also doing housewife. That is why, my lord, some amount.
Latavad.
The fine.
Anita madam, Latavad case. Latavad case.
Lata Wadhwa is reported in, my lord. I have Lata Wadhwa.
Where is that book? I give that. That I'm asking.
Lordship can distinguish on this way.
Hmm.
Exhibit P8, they have produced a master degree certificate.
Hmm.
She's a graduate, like my Lordship could have considered another 1,000 or 1,500 more.
We'll just look at it. In between, there was no occasion to look at this judgment.
Please, please.
Contribution of.
Family.
This is Lakshmidhar Naik versus Jugal Kishore Behra.
Lata Wadhwa case has been referred on that, my Lord.
Ah,
Basically, my Lord, in 1999, Lata Wadhwa case.
Yes, 852. 838. 852 to 855. Hmm. There is a latest judgment also after this. What is that?
Latest judgment.
After Ranjan Gogai's judgment, there is one more judgment. That is discussed in detail than this. It only said 3,000 per month from so and so, 15,000 per month for a household work. So some contribution to that is given.
But the basically, my Lord, Kirti.
Hmm?
Kirti case.
That is also there here.
Kirti case. In Kirti case and this judgment, my Lord, basically, my Lord, Lata Wadhwa case has been
Referred. But in this judgment, it is not
Lata Wadhwa
clear.
case. Please. Kirti case, my Lordship.
What is the citation?
Please.
What is the citation?
Please, please.
It is 21 or 20?
2021, my Lord, SCC 166. Volume 2. 2021. 2021. Volume 2, SCC 166. Till then, my Lordship could have disposed other matters, my Lord, after that.
Then the next one. Same file, not necessary you require another file. Numbers are one and the same. So next is MFA 559.
559, sixth number, item number 6. The synopsis.
It is MBC 11.
Yes, my Lord.
Where is the order?
MSc 11. MSc 11, that's from para 74. Readable 25 years, my Lord. PW2, principal of CIT College Gubbi. The document reflects that is an assistant professor and drawing salary of 20,000.
Court has taken?
The court has considered 20,000 only, after deduction 200 rupees
Towards
professional tax. 20,000 into 12 in 2 lakh
What are the
40,000.
injuries?
Death case.
Death, husband is the
Death
case.
case.
What's the case of
Death of a 25 year.
So income is taken at 20,000. Age is
25 years.
Future prospects were considered.
Everything.
50% added.
50% added.
So because of it. Then what else?
Only
What else?
50, instead of deducting 1/3, 50% is deducted. That is the main ground.
Yes. That we will do.
This is a married.
Only that much.
Small claimant, my lord, on that basis, my lord, 85 para extracted.
Huh?
Para 85, my lordship. Added 50%.
For 1 minute. What is the multiplier?
8.
18, 18. Madam.
Claimant is the wife.
Husband. Pooja Chinniwar is the deceased.
It's coming to 44 lakhs. Pradeep, it's coming to 44 lakhs.
One submission, please. If wife is only the dependent, not your lordship judgment is on this point, only 50 has to be deducted then.
Which judgment?
Today I have not, but it is, your lordship's judgment is there.
No law is laid down.
You can always 1/3. I have never deducted 50%.
50%, wife is only dependent.
It's in case of a bachelor, 50%.
50%.
Bachelor 50.
In case of wife, 1/3. That's what I've been doing consistently. If you're not happy, it comes to 44 lakhs, Pradeep. If it is.
Instead of 32 lakhs.
Husband is the claimant in this case. This case, my lord, husband is the claimant.
I said 44 lakhs. Nothing, as least 20,000 is taken, future prospects at 50%. Then again, 1/3 is deducted. It's come to 20,000 into 12 into 18, 43 lakhs, 20,000, 44,000, 36,000, 10,000. It's coming to 44 lakh, 10,000. Please come. Agreed with award passed in MFA number 559 of 2024. Dated dated 27 January 2023, whereby the claimant is before this court seeking enhancement of the compensation. In the first case, in the other case, I have narrated the facts, same facts for this also. The claim petition is filed, seeking compensation of how much in this case?
This case, my lord.
The appeal memo prayer part. That is
It starts where?
The first para, my lord.
First
80 lakhs.
Claim petition is filed, seeking compensation of an amount of rupees 80 lakhs. Something is wrong with the numbers. You say it is MBC 11.
MBC 11, 559 bar 2.
That's what I think. Wife, husband is the claimant. That's what I submit.
The husband, it is the facts of the case are the deceased has completed her BE MTech. She had academia excellence and she participated and presented many research papers in national conference. She is working as assistant professor at CIT Engineering College and also conducted private tuitions to PUC and BSc students and was earning rupees 45,000 per month. In support of the income, the principal of CIT Gubbi was examined as PW2. In his evidence, he has deposed a deceased working in his institution. And in order to prove it, he has also produced Exhibit P9 to 11. Exhibit P9 is the attendance register extract. Exhibit P10 is a casual leave certificate. Exhibit P11 is a salary slip for the month of March pertaining to the deceased. Appointment order dated 4/7/2014 also reflects the appointment of the deceased as the assistant professor in the college, in the said institute. And as per the evidence of PW2, her gross salary is rupees 20,000. Oh, I have made the calculation without deducting this 200.
Calculated.
No, I have not deducted this 200.
My lord, 83 page, para 83.
Now, yeah, now small difference is there, my lord, because 200 is not considered as deduction.
2,40,000 after deduction of tax 200 shall be deducted from the monthly salary. This is calculated, her income 200 is to be deducted from the total salary, professional tax and month of 200 into 12, 2,400. 2,37,600 would be the income.
No, what is it?
2,37,600 after deduction of 2,400 professional tax
Per year?
per year.
It comes to
2,37,600.
End of the page, please.
2,37,600.
income of the deceased is 2,40,000. It's 2,37,000.
600.
37,600. Then where the future prospects are added?
Next, loss of dependency.
85. That is 40% more instead of 50%, 50%. 40% could be considered.
It is she has the
Fixed salary. Not government, it's a private institution.
Anyway, it's
If my lordship is doing 1/3, my lord, that could be interfere by this.
my lord, it may be a cost.
In several cases, lordship, where there is no stable employment, my lord.
It is not.
40%.
We were taking, but so instead of doing all this yearly thing, is there any tax? No tax.
No tax,
tax.
that's what 2,400.
That's fine. So per month, that is, it comes to 18,000.
Per month, my lord?
18,000.
No, my lord, only 200.
200 per month.
19,000.
1
minute, 1 minute, Mr. Shastri. Here, there are
ಹೇಳ್ತೀನಿ
people
ತಾಳಿ
to
sir,
assist the court.
5 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ.
19,800.
19,800 is a monthly income.
19,800 into 40.
7,920.
7,920.
27,720.
27,720.
Divided by 3 million.
To 1.
9,250 would be the deduction.
9,240. It comes to
18,840.
18,840.
Sorry, 480. 18,480.
Into
12 into 18.
Comes to
25 ವರ್ಷ. Correct ಇದೆ 18. 39,91,680. 39,91,680.
Then 44,36.
It is already granted, please.
ಅಲ್ಲಲ್ಲ ಟೋಟಲ್ ಮಾಡಬೇಕು.
Yeah, we are making the total.
Please.
40,71,680.
It comes to 40 lakh.
40 lakhs, 71,680.
81,000, that
Yes,
is.
ma'am. 10,000, my lordship.
680. What did you write?
Only one submission, my lord. Only one submission. If my lord permits only. My lord, she is highly qualified and teaching in the
Yes.
B college.
Yes, Mr. Kasi, it is over. Yes.
50% are already considered. No appeal is filed. Oh, 40% seems to be
20,000. Court has deducted 200 towards the professional tax, and the income was taken as 19,800 per month. When it comes to the future prospects, court had taken future prospects at 50% and
50%.
deducted 50% and granted the compensation as per the table given below. Table is at 87.
Yes, ma'am.
Correct?
Please, ma'am.
7.
Correct.
Extract the table. When counsel appearing for the claimant submits that the court ought to have, she ought not to have granted 50% and ought to have granted 1/3, ought to have deducted 1/3. It is submitted that that the compensation that is awarded by the tribunal is not just and reasonable. Next, when counsel appearing for the respondent insurance company submits that the court had granted 50% prospects when she is not, if that's not a government job. Further, the court had rightly granted compensation in respect of other heads and no enhancement is called for. Next, having heard the counsels on either side, there is a material on record. As far as the income of the deceased is concerned, there is no dispute on that. Her income is 20,000 and 200 is a professional tax. Safely, her income can be taken as 19,800. She is a married woman. Hence, this court is inclined to deduct 1/3 as her personal expenses and 40% towards the future prospect, as it is not a government job. Future prospects at 40% will come to 7,920. Then her salary is 27,720. The 40%, the 1/3 comes to 9,240. Then her contribution to the family would be 18,480 into 12 into 18 is 39 lakhs 91,680 towards the loss of dependency. 44,000 towards loss of consortium, 36,000 towards funeral expenses, and in the light of the law laid down in Mekala versus so and so, 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 40 lakhs 81,680. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 32 lakhs 84,600 to 40 lakhs 81,680. Enhanced amount shall carry 6% interest. Is there any delay in this?
Yes,
Serial
ma'am.
number? This is 502. Yes, delay is IA number. This is
In all the cases, 272 days. delay.
1 minute. I have it.
272 days.
This is MFA 559 arising out of
11 of 2018.
2018. Delay of
570.
No, 272.
272 days.
IA number 1 of this should be a docket order. IA number 2 of 24 is filed to condone the delay of 272 days. Same condone, and in the order also the court has condoned the delay on condition. Hence, they are not entitled for 272 days. A memo is filed seeking dispensation of notice to R1, R2, R4, and R5. This also should be a docket order. Yes, Mr. R6, Mr. B. Pradeep shall file wakalat, takes notice and shall file wakalat within 1 week.
In all cases, I am for the third respondent, please.
You see, your name is there.
Please.
That means.
Next, you take the slips, you can give everyone. Yes, next. What about the previous case 3.2?
12 is here, MSC numbers. 563.
Where is the discussion, Pradeep, in this?
502, madam.
5 not?
7, MEC 7, madam.
No. In this judgment, where is the discussion I'm asking?
That
Discussion about,
there is some chart mentioned, madam. Before that, there is
monthly income,
personal expenses,
reduction
monthly
towards
income.
personal expenses,
Bottom, madam. Next, quantification.
adjustment for future prospect, increase for special circumstances.
Left side, madam, first page it has been discussed. Before that, calculation sheet.
if number yaad irodu. Hello. MSc number 7. 7 MSc number.
Assessment of monthly income.
Three-year-old boy
Yeah, although
and
it is correct that
4-year-old girl.
Claimants have been unable to produce any document evidencing gross income nor have established so and so, but that does not justify lowest so and so from the statement of documentary. Academic complaint is a very minimum wages. Other hands and division of comparison.
7 ಗೆ ಮಾಸ್ಟರ್ ಡಿಗ್ರಿ ಅಲ್ವಾ ಅದು?
That Agarwal judgment has been referred,
Hmm.
and afterwards, my lordship, there is discussion. Next page, all the citations has been
So
discussed.
ultimately, what is the crux of it?
Discussed.
How much to be taken?
14,000, I think.
Huh?
Left side, my lord, before chart, there is a discussion. 14,000 something has written on that. 41 years, 25,000, 25% future prospects. Before that page, my lord. Before that page, first.
Point out,
Please.
give it to him. I'm not able to see that.
Discussion. Discussion.
What is your qualification?
Is a
Master
degree. Master
Economics. Economics in master degree.
Judgment number 30, para 39, please, madam. Exhibit P8, master degree in economics and
Now, MFA 502
please, madam.
is arising out of MBC.
Seven.
MBA
Seven.
7, not 8.
7, my lord, 7. 7, the discussion is that, my lord, para 39, they have stated that, my lord, she was earning 12,000 per month as a assistant in SBI bank. With
Court
respect
has
to
taken how much?
9,500.
500.
Which year is the accident?
2016. Rightly considered, my lord.
9,500.
9,500. That is rightly considered. What I am going to say is that, my lord, as per Exhibit P8, reflects that deceased is a master degree holder in economics. The documents they have produced, not for that chart income. My lordship could have considered more than that chart income, laying upon that Exhibit P8 marks card, master degree certificate.
This year, for the year 2015,
16.
what, as per that notification, what is the amount?
That notification is less amount.
Will be less than this.
Less than that.
Then we will take 11,000.
qualification.
So what is the age?
36, my lord.
36.
15 is the multiplier.
40% is.
$15,400. 15,400.
Yes, yes.
Who are the dependents?
Husband and minor son.
Husband
Daughter.
Son, minor son.
It comes to 10,266 into 12 into 15.
Please.
It's coming to 18 lakhs 48,000. Two are the dependents, 88,000, 56,000 and 10,000. It's coming to 19 lakh 82,000.
Please.
In all these matters, both the insurance companies are liable to pay equally. One of the condition in all the matters. No, agreed with award passed in MFA number, MBC number 7 of 2018. This is MFA 502. Agreed with orders passed in MBC 7 of 2018 dated so and so, passed by so and so. The claimants are before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 42. When counsel appearing for the claimant submits that the salary of the salary was taken at 9,500. It is submitted that as per exhibit P8, she has
Master degree holder in economics.
She is a master. She has done her masters in economics, and court ought not to have taken an income of 9,500 per month. It is submitted that the tribunal has failed to consider the qualification and the income and failed to grant a just and reasonable compensation. When counsel appearing for the insurance company submits that the court has granted a just compensation considering all the facts and basing on the evidence on record. No enhancement is called for. Next, having heard the counsels on either side, there is a material on record. There is no dispute about the fact that as per exhibit P8, she has done masters in economics. The court had taken 9,500 as income as per the table for the year 2016. Considering the fact and considering her education qualification as per exhibit P8, this court is taking 11,000 as the income. Future for prospects at 40% will come to 4,400. And the salary would be 15,400. 1/3 has to be deducted towards the personal expenses. It comes to 5,133, and the contribution to the family is 10,266 into 12 into 15 under the head of loss of dependency. The claimant is entitled for an amount of rupees 18,48,000 towards the consortium, 88,000. 36,000 towards the funeral expenses. In the light of the law laid down in Meghalaya so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 19,82,000. Accordingly, the appeal is partly allowed, enhancing the compensation from 17,17,060 to 19,82,000. Then, in the docket order, in this also delay of 272 days, same should come there. The delay is condoned on condition they are not entitled for so and so. Next, memo is filed seeking dispensation on notice to R1, R2, R4 and R5 dispensed with at the risk of appellant. In this, your name is there.
By 61.
Shankar Reddy, sir.
Shankar Reddy is appearing. Yes.
Attending in other cases.
Yes,
Referring
3.2.
non-other matters.
Huh?
It may be continued in this case also.
Pradeep,
Pradeep.
Mr. Pradeep appears for R6. Wakalat is necessary.
will
You
file
shall
it
file
in.
the wakalat within 1 week. Yes. Next. Then 3.4. This is arising out of MFA 561, arising out of
8,
Serial number 3, my lord, in synopsis. Para 43.
43 of the judgment, please.
1 minute. Serial number 3, MVC 8. In this also, look at this 561. Memo is filed dispensation or notice to same and delay also same in all the matters. Yes. Yes, Pradeep. Paragraph number?
Paragraph number, my lord, 43, my lord.
43.
43 table is on that, my lord, 49 internal page.
1 minute.
It's a case of injury, my lord.
49.
49 internal page.
On what ground you're seeking enhancement, Mr. Shastri?
My lord, I am not understanding what is the MUC number is going on or MFA number.
MFA 561.
561, my lord, by MUC 8 bar 2018, my lord. My lord, is a businessman and doing distributor in sanitary and electrical items, 39 years. But agreement and VAT certificate also produced. PW, he sustained. My synopsis make
9,500 is taken.
Please.
What is the evidence? What are the exhibits in respect to his income? Let's see the exhibits.
Malala, one submission, madam. Malala, he suffered brachial plexus injury. So he lost his one hand, upper hand, totally. It is only a cosmetic purpose. It is hanging. It is hanging. Doctor said, my lord, it's a 27% whole body disability. That is the crucial aspect. Since he suffered brachial plexus injury.
First of all, are you okay with that 9,500 or on that you want to argue?
It is no specific evidence is
So then leave it. 9,500 will take. Now come to the disability aspect. Where is the, how is it considered?
Whatever the doctor said, my lord, it has been considered.
No,
Whatever
my
the
lord.
doctor said, 27%, the same 27% whole body has been considered.
Then what do you want, sir?
ಇಲ್ಲ ಸರಿಯಾಗಿ ನೋಡಿ ಸರ್ page number 38 para 43
So because
para
all
54 my lord, para 54 mechanism.
The petition is having permanent disability towards particular limb up to 79%, only 27%.
Whole body.
Hmm.
As for the doctor evidence only, the MSCT is concerned 27%.
Yes.
But since he lost his right hand and because of brachial plexus injury, and he is doing the business of these electrical items.
Mr. Shastri, whatever you have examined the doctor, your doctor's evidence is considered.
Yes,
Above that, what is it we can consider?
My lord, I am not disputing. I am not disputing 27% disability. But my lord, because of he lost his right hand, he is suffering from physical disability to an extent 27%. I proved that he lost his right hand. It is only hanging. Only for cosmetical purpose it is other. Since his lucrative activity is curtailed to a larger extent, even he can't drive the vehicle. Functional disability may be considered more than this physical disability. That is my respectful submission. I am not disputing anything. But the pain and suffering, loss of minutes, everything is required to be enhanced. These pain and suffering 70,000. I may not entitle this enhancement. Disappointment.
Internal 49. Internal page 49. There
I've
is a
seen,
table.
I'm seeing that. Pain and suffering 70,000.
Yes, that may be correct.
Medical expenses as it is.
3,53,000. My lord, he was inpatient as per my notes, my lord. He is a total 7 days, my lord. He underwent several surgeries.
On higher side. Incidental expenses 20,000. Functional disability is required to be considered more. It is my
Future
responsibility.
medical expenses not entitled. What is the evidence of the doctor?
Future
PW2 Dr. Krishna Prasad Malad. PW2 Dr. Krishna Prasad.
What did the doctor say about the future medical expenses?
No, my lord, that's not granted.
No, not granted. What is the evidence of the doctor? Whether it is required or not required?
May I read the doctor evidence for that? Dr. Krishna Prasad, PW2, page number 96 of the trial court records. Malad, he lost right hand and further loss of sensation of this one, and the about assessment in respect of upper lip.
How many months income is considered?
3 months.
That we will consider another 2 months.
But he is unable to run the business. That is the doctor evidence.
First of all, they have not at all proved
That's
that.
why
whether
you
it is
are
running.
you are granted all this. You should have elicited all this from your doctor.
Yes, it is elicited. It is on record.
Yes.
It is on record, madam. That is why I am
Mr.
insisting.
Chatti, on the aspect of loss of amenities, we will enhance some more amount. 40% of future prospects were granted, that we will grant. What do you say about amenities?
35,000 I have awarded. Make it 50,000. 50,000. 35 instead of
We'll grant
35.
60,000, and then loss of future income, we will consider the future prospects. What is the age?
39 years. 3,800.
13,300
13,300.
into 12 into
27%.
into 12 into
27%. 27%.
multiplier.
15. 6,46,380.
What about future medical expenses?
There is no such, but it requires, because these brachius plexus injury, my lord, I am repeatedly telling that it requires a whole life treatment, and it is a day by day it is shrinking, and he lost the right hand. That is not forthcoming in the.
Pradeep, loss of future medical expenses.
30,000.
It's coming to 11,66,980 against 9,68,300. Please come. This is MFA 561 against the order passed in
8 of 18.
MVC 8. The
Next.
how much was claimed in this?
This
Claim petition was filed seeking enhancement. The claim petition is filed seeking compensation of
48 lakhs.
Seeking compensation of 48 lakhs for the injuries sustained by the claimant in the accident. The petitioner, the claimant was treated for cervical spine, displaced fracture, transverse process through forearm, transverse cerium of C7 on right side, right vertebral artery at the dame level demonstrates normal contrast opacification, undisplaced fracture, transverse process of C7 on left side, and CT brain. no intracranial hemogram oblique bony injury.
64.
Subdural hematoma in right parietal and occipital scalp, comma. Medical records reveals that the injuries are grievous in nature. The court had, considering the court had granted an amount of rupees 70,000 towards pain and suffering. When it comes to the disability, it is the evidence of the doctor that the claimant had sustained 75% limb disability and 27% whole body disability. Court had taken the income at 9,500 and granted the 9,500 and 27% disability and granted the income, granted the future loss of income. The compensation that is awarded by the tribunal is as follows, para number 61. Land counsel appearing for the claimant submits that the court had not granted a reasonable compensation at the head of loss of amenities. Further, it is a functional disability and the disability ought to have been taken. The more percentage of the disability ought to have been taken. Further, the court had not considered the future prospects when the disability is 27%. It is submitted that on all counts, the compensation needs to be enhanced. Land counsel appearing for the insurance company submits that as per the evidence of the doctor, PW2 court had rightly, as per the evidence of the doctor is taken in toto and the court had granted the compensation and there are no grounds to enhance the compensation. Next para, having heard so and so. The compensation that is awarded under the head of pain and agony, medical expenses, incidental expenses, no interference is called for from this court. Then coming to the future medical expenses, considering the evidence of the doctor and the injuries, this court is granting 30,000. Coming to the loss of income during the later period, 9,500 into 5, 47,500. Then the loss of income due to permanent disability. The submission of the land counsel with the petitioner, this court is not able to appreciate as the doctor's evidence is 27% to the whole body and the tribunal had rightly considered. However, the tribunal has not awarded the future prospects and this court is awarding the future prospects. So 9,500 future prospects at 40% comes to 3,800. That is 13,300 into 12 into what you said the multiplier is
15.
15 is 6,46,380. Then coming to the loss of amenities, this court is granting an amount of rupees 60,000. In the light of the law laid down in Mekala, legal expenses 10,000. Altogether, the claimants are entitled for an amount of rupees 11,66,980. Accordingly, appeal is partly allowed, enhancing from 9,68,300 to 11,66,980. In this also same those two, that loss of, yes, next. That she has already taken. Yes, next. Now, as per the, this is also over. Next 3.5. MFA 563, erasing out of
12 of 2018.
huh?
MEC 12 of 2018.
Yes, 12 of 2018.
88.
Para 88, please.
88.
Injury case.
In all these matters, for the respondent number 6, in this matter also, Pradeep shall file vakalat in 1 week. Yes. I think this we can complete and go because the same facts, no? Same, so that it will be easy. Yes, paragraph number?
Para 88.
90?
88, my lord.
88.
88.
Injury is next page, please.
Issue in 5. No, it is not, you're saying about the running page.
Please. Judgment page number.
Para 88.
Para
Para 88,
is
internal page
issue
63.
number 2 to 5 in MVC 12. Where is the table?
Table, my lord, internal page 71.
103 paragraph. So what, yes, Mr. Shastri, what way?
My lord,
what is
actually,
it?
my lord, only one submission. My lord. Actually, I extracted everything, made hard homework and extracted everything in my notes, but I failed to this convince my lord regarding my notes. Anyway, it's okay, my lord. I will only by relying upon my notes, my lord, I will argue. Say 65 years, a retired employee, my lord. But he also helps in his son's business. Claims to-
Before you go into that, come to the table at 103.
Pain and shock and agony 50,000, my lord.
What is your submission on that?
My lord, apart from this fracture injury, the fracture of clavicle, fracture of scapula, fracture of third rib, and severe head injury, that is more important. Subjugal hematoma, my lord, is a diffused axonal injury, blood clot in the brain.
What do you say?
My lord, it
Loss of future
resulted.
earnings. There is no loss of future earnings. They are getting the pension.
Well, it is not
Pain and
pension.
agony, what do you say?
My lord, this resulted in 70.
Para 98, my lordship.
No, pain and agony.
Pain and agony. 50,000 is awarded.
So how much?
Another 10,000.
No, he says 3 fracture injuries and 1 head injury.
Another 20,000, please.
And a 65 years old male.
Medical expenses.
Actuals, please.
2,34,800.
How many days was in hospital?
16 days. Total 2 days.
I think in all the cases, the court they do not want to do any independent exercise. So for everyone, 20,000. Incidental expenses. In every case, future medical expenses not entitled. Loss of income during laid up period.
8,000 into 3 months, my lord. That is wrong, my lord. It is required to be considered because as per chart, my lord, because he claims to be earning 20,000 by way of helping his son's business. But just my lord has disposed of the matter. That is his son's. He has earning some lucrative activity. My lord, tribunal has considered 8,000 and 15%, my lord, physical disability, function disability is considered. According to my lord, is 75% neurological disability. My lord. Apart from this fracture, 75% neurological. He is unable to take any independent.
Let him not do. He is already 62 years old.
65.
No, 62. My lord, I am now in 62.
The
I can
discussion
work
is
up
para,
to 80.
discussion is para 98. my lord.
You can sit and work.
No, I am also agriculturist, my lord. Pradeep, no.
Yes, Mr. Shastri.
No, off the record speaking.
So loss of income during the laid up period.
This case, my lord, 8,000 as considered.
It is supposed to be
9,000.
500 into 4 months. It's 38,000.
Well, disability aspect is
How
important.
much is the disability?
Disability 15%, the actor has considered, the tribunal has considered.
No, after retirement, if he's working,
Assisting
Only
his son.
7 is the multiplier. That is why functional disability may be taken higher side.
The discussion is that if really petitioner had any intellectual disability up to 75%, he may not properly respond in his cross-examination.
Dr.
Sir,
himself is having intellectual disability of 75%.
75%.
70 neurological
That
is not
is
intellectual.
65-year-old
Neurological.
person,
Neurological disability.
Sir, can give evidence. That's what my lord, MSCT has discussed. Petitioner himself filed affidavit in lieu of chief examination, got marked exhibit P1 to P7 and
No,
properly
how-
answered in the
no.
cross-examination.
This 1,08,000 is how the court has quantified this?
15% whole
And
body
7.
disability.
7.
8,000 income and 7 multiplier.
Yes, we will take 9,500 and do it.
15%, my lord, for a aged 65 years in the fag end
So
of his life.
9,500
Madam,
into 12 into what is the multiplier?
7.
7 into 15.
15% seems to be lower side.
1,19,700.
Loss of amenities.
25,000 is awarded, my lord.
25,000. Another
Court has not considered the 75% intellectual
That's
disability.
what, another 25,000.
The reasoning
is
at page number 69, please. One line kindly looked into that, please.
My lord, neurological disability, my lord, not intellectual.
Another 25,000. And future medical expenses?
Not awarded.
No evidence is forthcoming, my lord. But
20,000.
Actor
he,
has not stated. 20,000. Actor has not stated.
Yes. Four lakh. Some calculation somewhere has gone.
5,62,500.
5 lakh?
62,500.
Please come. This is MFA 563, arising out of MVC 12 of
12 of
2018. And this also 272 days delay, R1, R2, R4, R5, and Pradeep shall file wakalat within
18
1 week.
lakhs. 35 lakhs. Last
The
payment. 35.
agreed by so and so, the claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. That is at paragraph number 103. Land counsel appearing for the claimant submits that the claimant is aged about 65.
Please, 65.
65 years, and because of the injuries sustained by the claimant, as per the evidence of the doctor, the intellectual disability is up to 75%. The court, considering the fact that he is able to respond and also answering the questions of the court, had considered the disability at 15%, 15%, and granted the compensation. Land counsel submits that when the doctor's evidence is 75%, the court ought not to have taken 15%. Further, under the loss and the head of loss of income during the later period, amenities, the amount that is awarded is not reasonable. No amount is awarded and head of future medical expenses. Further, when this accident has taken place in the year 2016, court had taken 8,000. 8,000 as income, ought to have taken 9,500. Hence, on all these counts, the compensation needs to be enhanced. And counsel appearing for the next para. The insurance company submits to the court as awarded a just and reasonable compensation. Compensation. The petition, the claimant has sustained a head injury. Considering the same under the head of pain and suffering, this court is granting 70,000. Medical expenses and incidental charges are granted as per the evidence and no interference is called for. Coming to the future medical expenses, this court is granting 20,000. Loss of income during the later period, 9,500 and 500 into 4, 38,000. Loss of future income, this court is considering the disability of 15,000, which is rightly considered by the court, 15%. 9,500 into 12 into 7 into 15 by 100 is 1,19,700. Amenities, this court is granting 50,000. Future medical expenses 20,000. In the light of the law laid down in make clauses so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 5,62,500. Yes, next, the last one.
Yes, ma'am.
564.
Para 62.
Para?
62.
MSc
9.
9.
This also same, the dispensation. What you can do is, you can, like how the trial court has done, one order you can make all this. Just say, because all these MVCs are disposed of by a common order. So these appeals are also disposed of by a common order. And in one order, all these can be giving a side heading. Yes, paragraph number?
62. Claim by husband, my lord.
1 minute. It's a case of death.
Death, my lord.
What is the qualification of the deceased in this?
9,500 consider, my lord, here.
Income. I mean, the qualification of the deceased.
61
She
years.
is a housewife. She is
Yes.
housewife.
61-year-old.
61.
Conclusion is 61 years per PM report.
So,
She is
income is taken 9,500.
9,000.
9,000?
They claimed that, my lord, 9 to 10,000.
9,500 or 9,000 taken?
Yes, 9,500 consider.
Considered.
They
Then,
pleaded that, my lord, 9 to 10,000. MSCD considered 9,500. Deducted 50% towards personal expenses and awarded 3,99,000. Applied multiplier of 7.
no future prospects.
61 years.
Death certificate ಅಲ್ಲಿ 67 years is there. In the death certificate, it is the death of, the age of the death is 67 years. Please. Judgment number 51. 7th line. Please.
So 6334,
Please, my lord.
1/3.
1/3.
12 into what is the multiplier?
7.
It comes to 5,32,056. Who are the claimants?
Husband. only.
Husband.
Only husband. 44,
That is rightly granted. 16,000.
10. It's coming to 6,22,056 against 4,76,000. This please come. This is MFA 564 arising out of MVC
9 million. 9 of 18. Claimed amount 18 lakhs.
the agreed with the so and so, the claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at page paragraph number 68. Land counsel appearing for the claimant submits that the tribunal has taken ought to have taken 10,000 as income. Further, the court has deducted 50%, and then the other heads also the compensation that is awarded by the tribunal is not just and reasonable. Land counsel appearing for the insurance company submits that the court had rightly granted compensation and no enhancement is called for. In this case, according to the claimant, having heard so and so, in this case, according to the claimant, the deceased was earning 9,500 to 10,000.
9 to 10,000.
9,000 to 10,000, and the tribunal, as there is no other evidence, had rightly taken 9,500. As rightly contended with the land counsel for the Respondent, reconcile for the claimant, the court ought to have deducted 1/3, that is 3166. It comes to 6334 into 12 into 7 under the head of loss of dependency, 5,32,056. Consortium 44,000, funeral expenses 36,000, and in the light of the law laid down in so and so 10,000. Altogether, the claimants are entitled for an amount of rupees 6,22,056. Accordingly, the appeal is partly allowed by enhancing the compensation from 4,76,000 to 6,22,056. This also same. So what you can do is, after doing all that, the PS will give you that order. End of it, all those, the one with regard to the delay in all the cases, because of similar delay, his filing the wakalat and other notes are there. As it is, you can take for all one at the end.
One submission. In all cases, liability will be
All
equally.
that 50% I said, both the insurance companies are liable to pay.
Malad, another one submission, Malad. Not on quantum or anything on merit. Malad, only the matter which is now kept pending. It may be de-linked, and these are all the papers, remaining papers may be sent back to the tribunal by de-linking this matter.
3.1 is de-linked.
And all the papers may send
They will
back.
go, they will go. Yes, next. Yes.
We have the first respondent.
Yes.
That the case of death, the liability of the insurance company is exonerated on the ground that the driver did not have driving license. And the liability is fastened on the owner of the vehicle.
On the ground?
No DL.
No DL.
No DL.
So what is
Earlier to the pay and recover.
pay and recover will apply. Then coming to the compensation?
That the deceased was aged around 50 years.
Hmm.
The income date of accident is 2/7/2020. Income is, he was a cleaner. The income considered at 10,000 rupees.
According to them, what is their income?
Please, Malad.
According to them, what is
They
their
claim
income?
15,000 rupees income.
So 14,500 we will take.
14,000.
14,500.
14,000. 2019 accident.
Oh, 19, 14,000. Yes. Age is 50 years.
50 years. 10% future prospects is already.
10 or 20.
10.
That is 1,400.
1,400. 15,400 into 12, 1,84,800
15,400
into 12.
And it's a case of death, you are saying?
Please,
A
Malad.
case of death.
Case of death.
How many are the dependents?
3 dependents.
1/3.
1/3.
It comes to 5,133.
1,84,800 divided by 1/3, 1,23,200.
10,266 into 12. What is the multiplier?
Multiplier is 13.
It comes to
16,01,600.
1,600. You said 3 are the dependents.
Please, Malad.
4 into 3 into 44.
Conventional as
1,32,000. Then 36,000, 10,000. You have calculated
Malad, I have taken 1,50,000 rupees.
1 lakh?
50,000 globally. The other conventional rates.
Oh, no, I have recalculated
16,01,600.
1,600 plus 1,32,000 plus 36,000 plus 10,000. It's coming to 17 lakhs 79,600. Please come. Agreed with award passed in MVC number 26 of 2021, date 16th June 2023. The claimant is before this court seeking enhancement of the compensation, as well questioning the liability that is fixed on the owner of the vehicle. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the death of the deceased in the accident. The tribunal has fixed the liability on the owner of the vehicle on the ground that As on the date of the accident, the driver of the offending vehicle was not having the effective driving license. The owner has not even taken sufficient steps to ensure that there was no breach of terms and conditions of the policy, and hence held that the insurance company is liable to pay the compensation. When it comes to the compensation, the tribunal has awarded the compensation as per the table given below at paragraph number 21. Extract the table at 21. The land counsel appearing for the claimant submits that the tribunal, though there was no driving license, still the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. But the court had wrongly fixed the liability on the owner alone by exonerating the insurance company. It is submitted that the compensation that is awarded by the tribunal was not just and reasonable. The court had taken the income at
10,000.
10,000 and ought to have taken at 14,000 as this accident has taken place in the year 2019. It is submitted that on other conventional heads also, the amount that is awarded by the tribunal is not reasonable. Next para. Land counsel appearing for the insurance company submits that the court had reasonably had considered all the aspects and had granted a reasonable compensation and no enhancement is called for. Next, having heard the counsels on either side, there is a material on record. First, coming to the aspect of liability, just on the ground that the driver of the offending vehicle was not having a driving license, that itself is not a reason to exonerate the insurance company. Hence, in the light of the law laid down in Swaran Singh's case, the principle of pay and recover will apply. The insurance company shall pay the compensation and record the same from the owner of the vehicle. Next, coming to the compensation. This court is taking the income at 14,000 and 10% future prospects would come to 1,400. That is 15,400. There are three claimants. 1/3 has to be deducted towards personal expenses. That is 5,133. Then the contribution to the family is 10,266 into 12. What is the multiplier?
13.
13 is the multiplier. Under the head of loss of dependency, the amount comes to 16,01,600. Towards the consortium, 1,32,000. Funeral expenses 36,000. In the light of the law laid down in Makel House so and so 10,000 legal expenses. Altogether, the claimants are entitled for an amount of rupees 17,79,600. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from rupees 12,34,104 to 17,79,600. The enhanced amount shall carry 6% interest. The insurance company shall pay and record the same from the owner of the vehicle. Yes, next. Any delay in this?
Delay of 100 days.
Huh?
100 days.
It is condoned?
Condition.
100 may not be a condition. Yes.
No further.
Yes, next.
Till number 5. Gopal Krishnayan for appellant.
Kindly pass over, my lord.
Andula Tejasvi.
I'm appearing for the second respondent.
Pass over. Next 6.
Till number 6.
Yes, Pradeep.
Questioning the negligence as well as quantum error. So far as negligence is concerned, the inmate of the car also sustained injuries, succumbed to the injuries. That case we have satisfied.
It's a case of death.
Case of death, my lord. MEC arising out of 1230 of 22.
MVC?
1230 of 2022.
1230.
Please, ma'am.
Where is that table?
Please. Table, my lord, as per chart only income consider. As per the chart only income consider, my lord. We are questioning that, my lord, minimum wages to be considered, but anyhow, my lordship is consistently considering the chart income. I'm not going to say all the further arguments on that. So far as negligence is concerned, my lord, as per the exhibit P4 sketch, it's a curve road, my lord, head-on collision, the accident has taken place. This is a driver.
Where is the finding of the court?
Finding para 13, my lord.
Para
Now, my lord, charge sheet is against the insurer of the Innova car only. Para 13, my lord.
Yes, yes. It is 1230. Agreed with the award passed in MVC number 1230 of 2022, dated 8th January 2024 by so and so. the insurance company is before this court, questioning the negligence and the quantum. The tribunal had granted the compensation as per the table given below at page number 20, paragraph number 22 extracted.
31. Para
Paragraph,
31.
paragraph number 31, extract that. Land counsel appearing for the insurance company submits that the court had taken the income at
Income 15,500.
15,500 is taken. Court ought to have taken how much?
Minimum wages, my lord,
For
14,000.
the minimum
Minimum.
wages, court ought to have taken the income. It is submitted that the accident has taken place at a curve. There is a contributory negligence on the part of the claimant, and the same was not considered by the court. The contributory negligence affect 50% as it's a head-on collision ought to have fixed, should be fixed on the deceased. Next part. Though notice is served on the respondents, no wakalat is filed. Next, having heard the counsel for the appellant insurance company, there is a material on record. The court, this accident had taken place in the year 2022. 22, court had taken 15,500 as income. And this court do not find any reasons to interfere with the quantum of compensation, which is a just and reasonable compensation. Then coming to the second submission that there is a contributory negligence, that also this court is not able to appreciate as the insurance company has not adduced any independent evidence in that regard. And the charge sheet is filed against the driver of the offending vehicle. In these circumstances, even that submission cannot be considered. Accordingly, the appeal of the insurance company is dismissed. The amount in deposit shall be forthwith transferred. Next.
Case number 7, Uday Prasad KT.
Yes.
Appellant, Sitaram Rao.
The case of death. No.
Case of?
Case of death.
Where is the table? Age?
The 15% contributory negligence has been held against the deceased. I have also challenged that. He was riding the motorcycle. This lorry came from his.
You are on the quantum or on the?
Both.
So first let's complete quantum.
Yes.
Yes. What is which year is the accident?
2022.
22. How much is considered by the court?
Court has considered 15,500. That is
So
correct.
there is not. What is the age?
Yeah, age is
22.
22
Future
years.
prospects are considered? That's also
Yeah,
considered.
that also considered.
So as far as the loss of dependency is
I have
concerned,
no
nothing.
grievance.
So loss of dependency as it is.
Yes, and conventional leads that has to be.
1 minute, 23 lakhs, 43,600.
Yes.
Then how many are the dependents?
3.
Father and mother.
My parents.
88,000.
Yes.
2 into 44, 88,000, 36,000.
Yes.
And 10,000. Yes.
Now throughout the.
So what the change, the difference would be 8,000 plus 6,000. 8 plus 6.
That is regarding quantum.
1 minute, 8 plus
But
6.
this 15% has to be
1
set.
minute, 1 minute. 14,000 we have to add here. That is 50, 53 plus 14, 60. 53 plus 14?
67.
63 plus 4, 67. 67, 600. Please come to that aspect of,
Yes.
where the court has discussed.
Para 16 of the judgment.
Para 16. Yes.
On Perugunal's first sketch and charge sheet, it is disclosed that on so and so, driver of one canter lorry bearing number so and so drove the same in a rash and negligent manner, came at high speed and dashed the deceased motorcycle from behind and caused the accident. And in para 18, after careful scrutiny, exhibit P1 FIR, P2 complaint, 3 death intimation, 4 submission, P5 expert. It appears that this accident occurred due to rash and negligent driving of the driver of canter lorry bearing registration.
What is this? The driver has hit the vehicle from behind
Yeah.
and there is no other evidence, and just because no driving license contributed.
Yes.
He was 18 years, 2 months.
But
That is the,
there
that is
should
the
be-
reason I am not.
No,
defending.
I'm saying if there is
Reason is-
evidence that because of his lapses, accident has happened, we can understand. Yes, please come. The agreed with award passed in MSc number 5610 of 2022 dated so 28 June 2023. 23
Yeah, and
by
what-
so and so.
Sorry, one more. The medical expenses, nearly 4,50,000 rupees he has spent. The evidence has come that he has reimbursed by the insurance company to the extent of 4 lakhs. 50,000 rupees has not been granted.
Have you seen that?
No,
Please look at it. Or shall I pass over?
no, I'll just.
Where is that discussion?
Yes. No, no discussion at all. Nothing has been.
Then where from you're saying this?
Yes. Here in the exam, in cross examination itself, it is true to say that the medical bills of rupees 4 lakhs is claimed through insurance company. It is false to say that remaining 50,000 medical bills is also paid through insurance company. Therefore, 50,000 rupees has to be included.
50?
50,000.
Then it comes to 25 lakhs 17,600.
Yes.
What did you write? Sensible. The claimants are before this court. The claimants are before this court seeking enhancement and also questioning the contributory negligence fixed at 15% on the deceased. Land counsel appearing for the appellant submits that. In the entire award, the court had discussed about how the driver who's offending vehicle was driving the vehicle in a rash and negligent manner and how he has contributed to the accident. But when it comes to the finding, as it is contended that the deceased was not having a DL as on the date of the accident, the court gives a finding that there is a contributory negligence on the part of the deceased and it is fixed at 15%. Then counsel submits that the said finding of the court is without any basis and the same needs to be set aside. Then coming to the compensation, it is submitted that under the conventional heads he is entitled for 88,000 towards loss of consortium, 36,000 towards funeral expenses. Further, he had spent an amount of rupees. The claimants have spent an amount of rupees 2 lakh.
4,50,000.
4,50,000 towards the medical expenses. In the evidence, it has been elicited that 2 lakhs has been reimbursed by the
4 lakhs.
4 lakhs is reimbursed by the insurance company. And as far as the 50,000 is concerned, the claimants are entitled, which was not granted by the tribunal. It is submitted that on these counts, the compensation needs to be enhanced. Land counsel appearing from the insurance company submits that court has rightly fixed a contributory negligence on the deceased as he was not having a driving license and his age about 18 years.
18 years, 2 months.
18 years, 2 months. And as far as the quantum is concerned, the court has rightly considered and granted the compensation and no grounds are made out to interfere. Next para, having heard so and so. First, coming to the aspect of contributory negligence, in the entire order, the court discusses about how negligent the driver of the opposite vehicle is and how because of his negligence, the accident had taken place. In one line, considering the contention of the insurance company, the tribunal comes to the conclusion that there is contributory negligence. Admittedly, in this case, the vehicle has come from the back and hit the vehicle. The charge sheet is filed against the insured vehicle. In these circumstances, the finding of the apportionment 50% negligence on the deceased is contrary to the evidence available on record and the same needs to be set aside. Next, coming to the quantum, as rightly argued by the land counsel for the appellant, they're entitled for loss of consortium at 88,000, 36,000 towards funeral expenses and 10,000 towards legal expenses. And as far as the loss of dependency is concerned, that is 23 lakhs 43,600. Court had rightly granted, no interference is called for. Then a perusal of the cross-examination shows that there is reimbursement of 4 lakhs, but as far as the 50,000 is concerned, as from the evidence on record, this court deems it appropriate to grant medical expenses of 50,000, which is not reimbursed by the insurance company. Hence, the appeal of the insurance, the claimant is partly allowed by enhancing the compensation from an amount of rupees 24 lakh 53,600 to 25 lakh 17,600 and 600. The insurance company, the enhanced amount shall carry 6% interest.
And
61 days.
negligence is 15%.
That is all, because when it is not calculated, it amounts to so. Then where is the
61 days.
161 days.
this court has condoned the delay of 161 days on condition, and the claimants are not entitled for the set period. Yes.
Chair number 8. Putraj.
1 week time may be granted some inconvenience.
Huh?
1 week time may be
For what?
granted. Some inconvenience.
List is matter in the month of January. Yes, next.
Chair number 9.
Yes.
Yeah. The table is at internal page 17, case of injuries.
How many are the injuries?
Only one. Sustained a right distal both bone leg fracture.
40,000 pain and suffering.
Yes.
Medical expenses, how much?
As per bills.
40,000.
612.
612. How many days was in hospital?
14 days.
Incidental, how much was granted as it is?
Yes, it is.
Hospital expenses also 14,000.
Yes.
Then loss of income during later period, which year is the accident?
2021.
2020. So 15,000 for how many months it is granted?
3 months. 3
Well,
months.
grant for 4 months.
Another 9,000.
15,000.
15,000. Court has taken?
12,000.
I'm taking 15,000. Then
And
loss of income during the later period. Yes, coming to the loss of future income.
PW2 doctor says 48% to the limb and whole body 16%.
40?
8% and whole body 16%.
Court had taken?
12%.
Because he's not a treated doctor, that's why the tribunal has considered 12%.
By
Just-
treated doctor
just
cannot.
for the purpose
No,
of
no, the
assessment,
doctor
he has
who,
been
no, no, the
examined.
doctor who has not treated cannot give the evidence.
Not like,
So according to the doctor's evidence, how much?
16,000, 16%.
So 15,000 into 12 into what is the multiplier?
13, 50 years.
To 16 by 100.
3,74,400. 3,74,400.
3 lakh?
74,400.
Yes. Loss of amenities, how much is granted?
Loss of amenities,
Community 15,000.
15,000 only.
This is disability of how much? 16%.
16.
Another 15, 30,000 will grant.
Yes. Future medical expenses,
According to the doctor,
doctor has not said, court has considered 15,000.
will grant as it is. No, he said there is a, I mean,
Yes.
future operation is required.
Implants are there, he has to undergo.
Then 30,000. It's coming to 5,99,012. against 3,70,252. Yes, please come. Agreed to the award passed in MVC number 4236 of 2021 dated 29th August 2023 by so and so. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 28. Land counsel appearing for the claimant submits that when the claimant has sustained a grievous injury under the head of pain and suffering, the court has not granted a reasonable compensation. The court, when this accident had taken place in the year 2021, court has taken the income at 12,000. Further, the doctor's evidence is that the disability to the limb is 48%, to the whole body 16%, but the court without any basis has taken the disability at 12%. Further, under the head of loss of amenities and future medical expenses, the amount that is awarded is not just unreasonable. Next, when counsel appearing for the insurance company submits that the doctor who has given the evidence is not a treated doctor. As such, the court had taken 12% as the disability, and there are no other grounds to interfere. It is submitted that already the court has granted a reasonable compensation, and there are no grounds to interfere. Next, having heard so and so, considering the fact that he has sustained one fracture injury, this court is granting 40,000 towards medical expenses and incidental expenses. Court has granted a reasonable amount, and this court is not interfering. Coming to the loss of income during the later period, as this accident has taken place in the year 2021, this court is taking the income at 15,000 and for 4 months, 60,000. Loss of future income, coming to the loss of future income. It is not that if a doctor who is not treated, his evidence cannot be considered. If the evidence is trustworthy, court has to take into consideration, and just like that, the doctor is not a treated doctor. The court cannot discard the evidence of an expert. Hence, this court is inclined to take the 16% as stated by the doctor. 15,000 into 12 into 13 into 16 by 100 is 3,74,400. Coming to the loss of amenities for a disability of 16%, this court is granting 30,000. Future medical expenses, as is an accident of 2021, this court is granting 30,000. In the light of the law laid down in Meghalaya, 10,000 legal expenses. Altogether, the claimant is entitled for an amount of rupees 5,99,012. Accordingly, appeal is partly allowed, enhancing the compensation from 3,70,250 to 5,99,012. Any delay? 198 days on condition. They are not entitled for that. If it is not there, not there. Tell her that. Next.
Cell number 10. Cell number 10. Or Shashidhara.
Yes.
Quantum Millet. Para 33 of the judgment.
Para
33.
33.
Date of accident is 2020.
1 minute. 20?
2020.
How much was considered?
Income was taken rightly, Millet. Only consortium only.
Oh, it's a case of death.
Yes, Millet.
So
14,500 and.
No, what consortium? This is a case of injury.
No, death, Millet.
Death Millet.
Para 33 of the table, Millet.
MFA
4550.
of 24.
Arising out of MVC 651, Millet.
Oh, there are 2 MVCs. Page number?
33, Millet. Para 33. Para 33.
Para 35.
Page number 29, madam.
1 minute. Para 35.
33.
Yes.
Para 33.
So as far as the dependency is concerned, no issue.
Yes,
So loss of dependency.
5 members is there.
How many are the dependents?
5 members.
Oh, 792. 5 into 44. How much?
2,20,000.
2 lakh?
20.
36,000, 10,000. It comes to calculated
25 lakhs 46,792.
25 lakhs.
46,792.
Please come. The agreed with award passed in MBC number
651 of 21.
51 of 2021, dated 26 July 2023. The claimants are before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 33. Learned counsel appearing for the appellant claimant submits that as far as the loss of dependency is concerned, the petitioner, the appellants are not aggrieved. And when it comes to the conventional heads, when there are 5 dependents, the court had not granted a reasonable compensation. So the contention, the land council appearing for the insurance company submits that the tribunal has awarded a reasonable, just and reasonable compensation. Next, having heard the counsels on either side, so and so. Coming to the conventional heads, there are 5 dependents, 5 into 44 towards loss of consortium. It comes to 2,20,000. Funeral expenses 36,000 and the light of the law laid down in Michael or so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 25,46,792. Accordingly, the appeal is partly allowed, enhancing the compensation from 23,68,000. What is that?
1,78,000 is the enhancement.
23,68,792 to 25,46,792. The enhanced amount shall carry 6%. Any delay?
A delay of 237 days with condition.
Condition. They are not entitled for the interest for the period. You will have in the, if you take the order, this will be there. Just you have to write what is the days, how many days. We will see.
By mistake, I said the income will be considered at 14,000 rupees.
It is 14,500. Yeah, it's okay. You have taken. She has only, you take this as per this calculation. Yes.
Cell number 11, cell number 11.
In this case, I appeal for the appellant.
Yeah.
Insurance company appeal challenging the quantum of compensation. What has happened, madam, after the judgment was passed, we produced the idea of the election ID card. According to that manner, the court in the review petition, the court has come to conclusion there is a mistake committed by the tribunal. Reduced the calculation was done, but the tribunal has held that in a review petition, this tribunal is not having a power.
Let's see that.
Please, para 31 of the.
Para?
Page. Page 18 of the.
Yes.
Please come. Para, reason point number review petition, page number 30.
I think I'm not able to find it.
Page number 30.
Page number 30.
Page number 30.
Additional papers are filed. Some additional papers are filed.
Review petition, that's what. Revision copy. He came to know the disease was either. Along with the appeal, I produced that review petition copy.
But you have to question, you have to file 2 appeals.
That
Yes.
review petition is the, we have filed malad. Basing on that malad, reliance I am placing, challenging the original award because the review petition is not on the challenge. On the original order, I am challenging before your lordship. To support of the defense, I am placing this document.
But that's not the procedure, is it not?
This correct, but it can be. But what has happened, madam? They played a fraud.
That is true. There is an order in the review. That's where the whole reasoning is given. There is an original order. But you need to file an appeal against the original order and appeal against the review order.
No. Why I have filed para 9 of the judgment?
No.
Review order may kindly be seen, madam. What the court has observed, we prepared the appeal. The court has observed that you para 9 of the judgment. Insurance company is already in the appeal.
I understand all that. Technically, you need to file. You need to file 2 appeals. Yes.
He was yes about according to the court observation.
Where is the finding?
Reasoning para 7
in
the review. On going through the judgment passed by this court, he came to know the disease was there of 49 years.
Paragraph number 7 or 8?
7, Milad.
7 starts like PW1 filed affidavit by reiterating.
No. Review petition order.
Please show where is it?
Para 30.
Let us show.
In page 30, para 7.
Yes. Yes.
Deceased was aged about 14 years as per the voter ID card, and PM report, he was aged about 45 years, but as per the petition, deceased was 40 years. PW1 Parvatama clearly admit the age of difference of her husband at the time of accident. As per the other card, deceased was 41 years.
What was the age as per considered by the court?
Court has considered 31 years, my lord. In next page only they have given. But this court has taken 35
No, no.
years.
But as per the petition, the deceased age was 40 years.
41 year. But as per the ID card, my lord, he was aged about 49 year, and the court has come to conclusion, my lord, he was aged about 51 years. Calculation
But
was
as per
also,
the PM report, it was 45 years.
please,
Yes, that
As-
has to be taken.
as per the ID,
What, that we
yeah,
will forget.
both are same.
When that,
Both are same,
45 and 49.
please.
So we have to, what we have to take, 49 or for?
49, average, that means 47 years, my lord, the very same
We
multiplier.
will take 45.
Please.
And what is the conclusion of the court?
Court says the, but yeah, what they say, the
It
appeal,
has no power to review its own order.
please.
Who appears for the respondent?
Nobody has appeared, sir.
Some
All are
name I
served.
am seeing in the cause list.
All are served, my lord.
Manjunath BK for R5.
R5 is the owner of it.
Is
He
the
is the
owner
owner
of
of the vehicle.
the,
He is
he
nothing
is
to
not
do.
concerned with all this. Pay and recover is, it's an order of pay and recover. No?
There is no pay and recovery.
The,
Only quantum I am charging.
agreed by the orders passed in MBC number 161 of 2019 dated 6 March 2023 by so and so. The insurance company is before this court. The tribunal has awarded the compensation as per the table given below at paragraph number 13 extracted. The only grievance of the insurance company is that the court, the age of the deceased as per the postmortem report is 45 years. As per the ID card, it is 49 years, but the court had considered 35 years and granted the compensation. When once the award is filed, they have also filed a review before the court. So they filed a petition seeking review of the order, that is review REV/2/2023. The same came to be dismissed by order dated 28 February 2024, observing that the court has no power to review its own order. However, the court gives a finding that there is a mistake on the part of the court in taking 35 years, 35 years as age. So now let's do the calculation.
Calculation has to be done, my lord, because
So let's see. So what is, which year is the accident?
2019 is
2019. Look at it.
2018 is the date of accident, my lord. 12,500 is taken.
12,500.
It is taken, my lord.
25% future prospects.
Please.
It comes to 3125.
Into 12 into.
Yes. $15,625. How many are the claimants?
4. 4.
1/3 or 1/4?
1/3, madam, up to
1 divided by 3.
no. Well, court has taken 1/4 only.
Huh?
1/4 only there.
It has to be taken 1/3. Is 5208. 10625 minus. It comes to 10,417. And for the age of 45, what is the multiplier?
13.
Hmm?
13.
It comes to 16 lakhs 25,052. Then 4 into 44, how much?
1 lakh 32.
1,76,000.
4 into, please. $36.
It comes to 18,47,052. How much was awarded?
27 lakh 15,000.
27,15,000. What did you write? Court gives a finding that as per the PM report, postmortem report, the age is 45 years. Next para, though notice is served on the respondent, no wakalat is filed on their behalf. Next para, having heard the learned counsel for the applicant insurance company, there is a material on record. This accident had taken place in the year
18.
2018. The income has to be taken at 12,500, and as his age is considered as 45 years, future prospects at 25% comes to 3,125. His salary is 15,000, his income would be 15,625, and there are 4 dependents, 1/3 has to be deducted. It comes to 5,208. Then the contribution to the family would be 10,417 into 12 into 13. Under the head of loss or dependency, 16,25,052. Consortium 4 into 44, 1,76,000. Funeral expenses 36,000. Legal expenses 10,000. Altogether, the claimants are entitled for an amount of rupees 18,47,052.
25.
Age of 45, 14 is the mandate.
What, Mr. Shivannagowda?
14. My lord, 20.
If you are not confident, you should look at the table.
No, my lord. 1/4 only taken by the tribunal, my lord.
Much has to be 1/3.
No, 1/4 was taken.
Till
Major son, major daughter. No, my lord, 1/4 is taken by the tribunal. That is correct.
yes.
13 months. Blood.
Multiplier
1 minute.
Sorry, my lord, there is a mistake on my part regarding multiplier also, my lord. 14 it is. It is not 13.
I feel that you are all professionals, so I don't even look. I'm not looking at
No,
it.
my lord, by mistake I have not noted that. 45 ಮೇಲೆ 13 ಆಗುತ್ತೆ. 48. ಇಲ್ಲ 45.
Multiplier is 14.
ನನಗೆ ಅಷ್ಟೇ.
It comes to 21 lakhs 90,792. The 12,500. From there, you come from that. 12,500 plus future prospects at 25% comes to 3,125. That is 15,625. 1/4 has to be deducted towards personal expenses. That is 3,906. And the contribution to the family would be 11,719 into 12 into 14. It comes to 19,68,792 towards loss of dependency. And 4 into 44, 1,76,000 towards loss of consortium, 36,000 funeral expenses, 10,000 the light of so and so. Altogether, the claimants are entitled for an amount of rupees 21,90,792. Accordingly, the appeal of the insurance company is partly allowed, reducing the compensation from 27,15,000 to 21,90,792. The amount in deposit shall be forthwith transferred.
Cell number 12, Gurudev Prasad KT, N. Krishnan Swamy.
Take this.
Yes, of debt. So far as the loss of internal page 16, table is at paragraph 24. So far as the loss of dependency is concerned, I have no grievance. Rightly calculated. And 5 dependents, loss of consortium 2 lakhs, estate to 20, and transportation
How many there? 5.
5. And medical expenses as it is given. Right on the next date.
Medical expenses are how much?
Yes.
83,850.
And
Yes.
the insurance company has been exonerated on the ground.
The ground?
He had no driving license.
When is it, before amendment or after amendment?
After amendment,
Then what to be done?
if he is agreeable for the paid.
Exoneration holds good in view of amendment brought to MBI.
That's what I'm asking.
Then
Reluctantly, in fact, they have not even culled out this aspect in the judgment also, in the appeal memo also.
In the appeal memo, I have stated.
Subsequently, my learned friend has inserted exoneration is bad. My lord, he also restricts that it is restricted to 14 lakhs as against compensation.
No, if he is not agreeable, then this has to be kept pending till the disposal.
No. We will not keep it. In that case, that applies to you in all the cases. So many cases they have filed and they are pending before the Supreme Court.
It is for consideration.
No, what we are doing, whatever is a settled law, that we are considering. Yes, please come. Agreed with the award passed in MBC number 3486 of 2022, date 27 January 2024. The claimant is before this court seeking enhancement of the compensation and also the liability, questioning the liability that is fixed on the owner of the vehicle. The tribunal has awarded the compensation as per the table given below at 24, para 24 extracted. Then counsel appearing for the insurance company submits that, as for the claimant submits that, as far as the loss of dependency is concerned, the claimant, the court had rightly awarded, and the conventional heads, the amount that is awarded is not a reasonable compensation. Then coming to the exonerating the insurance company from the liability, it is submitted that the principle of pay and recover will apply, and though just because there is no driving license, that cannot be a ground for the insurance company. That cannot be a ground to exonerate the insurance company. Next one. Land counsel appearing for the insurance company submits that after the amendment dated
1/4/2022. 1/4/2022.
1/4/2022, the principle of pay and recover will not apply, and this accident had taken place on
19/5/2022.
19/5/2022, and the tribunal had rightly exonerated the insurance company. Next para, having heard so and so. The coming to the compensation, as far as the loss of dependency is concerned, it's not in dispute. Towards consortium, 5 into 44, 2,20,000, 36,000 funeral expenses and medical expenses as it is in the light of the law laid down in Mekala, 10,000 altogether. The claimant is entitled for 51,00,050. Then coming to the second submission with regard to the liability, in the light of the amendment that is dated so and so, and as this accident had taken place subsequent to the accident, the principle of pay and recover will not apply, and it is the tribunal had rightly exonerated the insurance company. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 50,039,050 to 51,00,050, and the enhanced amount shall carry 6% interest, which is liable to be paid by the owner of the vehicle. Yes, next.
Cell number 13. Cell number 13, Pradeep B. for appellant.
2 weeks. 2 weeks time.
Why?
And that is a bundle policy, my lord. I want to argue that matter.
Yes, list this matter in the month of January. Next 14.
Serial number 14.
Yes.
Anup
I
Sierra
appear for
Rao.
the third respondent in the serial number 14, my lord.
I go for the respondent
Well, that's
claimant.
appeal of,
Yes.
appeal of the insurance company, well, that's challenging liability, case of injury. Well, that's undisputedly, the claimant was traveling as a gratuitous passenger in a tractor trailer. Well, that's, in fact, I am the insurer of tractor, trailer was not even insured. In the cross examination, Manoj, he admits that he is an employee of Chaudeshwari Sugar Factory. I have taken a specific stand that there is no employer-employee relationship between the owner of the trailer and the claimant. There is no positive evidence let in by the claimant to show that he was not a gratuitous passenger or he was an employee of the owner of the trailer. Hence, Manoj, I am challenging liability.
Admittedly, he was an employee of a sugar factory at Mandya.
Who admitted?
Claimant is say. At that time.
And what is the evidence adduced by you to show that he is not? Yes. What is the evidence adduced by you to say that he is not?
Plus,
At the leisure time, he was going for loading for the mud. That's it. At the leisure time, he was doing night shift. At the daytime, he went for transporting the mud to the paddy fields, the coconut plantation.
What is his occupation?
He was a employee in a sugar factory. It's a private factory, sugar factory.
Employee in a sugar factory, leisure time he will go to.
Loader, unloader
Will
in a rural
work as
side.
working as a loader and unloader.
Daytime.
Employee of a sugar factory.
Yes, yes. Supervisor in a sugar factory. The rural side.
Is it
Some evidence has to be
supervisor in a sugar factory going for loading and unloading? How is it believable? I can understand you are a loader and unloader there, and you're doing when you free time you're
But
doing it.
actually, the accident and the prosecution papers also speaks out that the complaint also when he was traveling along with the mud on the trailer only that accident. It is not disputed.
The tractor and trailer is going with the mud, and you travel on that, you will not become a loader and unloader just like that.
Yes, yes, madam.
When you have an occupation of your own, this can't be believed. You are a supervisor. Why will you go to load and unload?
But actually, the owner has already permitted to travel on the trailer. If at all,
But you become a gratuitous passenger.
then if there are a full bench decision, pain recovery has to be done.
How can it be?
The allow case, gratuitous case passenger means it can be done.
With judgment?
Allow full bench bench of this court, my lord. Allow a case. Gratuitous
Supreme Court.
What has happened to the Supreme Court judgments?
There is a in Supreme Court judgment also they have.
Those are all the cases where under 142 in the facts and circumstances.
But
I will tell you what is the judgment.
September 2025, Malad Supreme Court has held that insurance company is not.
Even from the problem is we are extending it. That's it. As far as the gratuitous passengers are concerned, that's very clear. That pay and recover principle is no more there. View the judgment.
Let's
Pass on the judgment. Yes, that pay and recover will not apply.
Actually, if the claimant has gone for the limited period as a loader, he was not traveling as a passenger in the case. He was employed by the first respondent.
Where is the evidence?
The complaint and the cross-examination by the respondent number 1 also has contested the matter, and there is a prosecution paper also. I can read the complaint and also the charge.
Yes.
There is no bar to do any other work because he's not a government employee.
That aspect.
That I will read out the complaint and the charge sheet, my lord.
That's complaint
Charge
is
sheet
delayed by 3 days. my
The
lords.
court also did not given any disability.
Have you examined the owner of the vehicle?
Owner is contested the matter. Yes,
Examined him to say that you are working with him as a loader.
Yes,
and
made a
unloader?
suggestion. I just go the cross examination of
What
PW.
did he say?
One second, my lord. I will just go with the cross examination of RW1. I was working at in the Chamundeshwari Sugar Factory as a permanent employee. There are 3 shifts in the factory. As on the date of accident, I had a night duty. So during the daytime, I went to work with first respondent. This is the cross examination by
That is
owner.
your, I said, what is the
The
evidence? Other evidence, your self-serving statement.
No, this
will
is the
not
cross examination by the owner of PW1. He is making a suggestion.
What session is making?
The respondent number 1 is from Eladali, which is about 6 kilometers from my place. I was not going to work with the first respondent every day, but only when I was free, if I was called by the first respondent, it is true to suggest that on the same itself, I would get the wages of for the day. It is
And
true
what
to suggest
I have-
that I was.
Mr. Counsel, not about your evidence. Have you examined the owner of the vehicle, or the owner of the vehicle has admitted that you are working with him?
Yes, he has already filed the statement and everything.
Where is that? Please read from his statement that you are working with him. Just pass over, please look into that. Yes, next.
Cell number 15. Cell number
My lord,
15.
I am for the appellant, my lord.
Vijay Kumar.
My lord, kindly see, my lord, para 31 of the judgment.
Where is the other side? No representation. This is matter on, counsel for the appellant is present, no representation for the respondent. This is matter on 27th of November. Yes, 16.
My lord, records are available. If the records are not there, records may be required.
Call for by the next date of hearing, record shall be placed on, yes, should be called for.
Actually,
I appear for
Much
appellant, my lord. I request next week, my lord. I'll have next week, my lord.
Yes, this is matter on 26th. Yes, 17.